may be seated.
Good morning, ladies and gentlemen. Welcome back. Ms. Sawyers, would you like to call your next witness?
Yes, Your Honor. At this time, I'm calling Dr. Gard back to the stand, and he is with us via Zoom.
Okay. Now, ladies and gentlemen, Dr. Gebhardt is appearing via Zoom, and Dr. Gebhardt is still under oath. Ms. Sawyers.
Thank you. Yesterday, Dr. Gebhardt, you talked to us a little bit about a patient from Ukraine that you were treating. Do you recall that?
I do.
And if I recall, it was approximately a 6-year-old patient that you were treating for starvation, severe starvation.
Yes.
And in that treatment can you describe whether or not the patient, when you saw the patient, was able to walk or move around, or what was their physical ability?
He was not able to walk. He was cachectic and had very low muscle mass, very
And
lethargic.
is that consistent with someone who would be suffering from lethal starvation or serious bodily injury starvation?
It would be serious. It's obviously not lethal at that point, but it could become that way pretty quickly, yes.
And yesterday we heard several questions that were asked by the state regarding whether a particular factor was consistent with starvation. And you responded by saying, yes, particular factors were consistent with starvation, but are you saying that because they are consistent, therefore this is starvation?
That wouldn't be what I'm necessarily saying. It is when you say something is consistent with, things can be consistent with child abuse like a broken nose because someone hit them in the face, but it's also consistent with other pathologies. So if you had a bike accident or you ran into a basketball pole or something like that, those are also consistent with that type of injury. So saying something is consistent with a finding doesn't necessarily mean it is pathognomonic, like we had talked about yesterday.
And then in regards to diabetes, I think one of your comments yesterday was that in your opinion you didn't think it was diabetes. Do you recall that?
I do.
And can I ask you why?
I never saw a significantly elevated blood glucose that would kind of indicate to me that he was having elevated blood sugars, which is kind of one of the main factors for saying that someone has diabetes or diabetes mellitus.
Okay, and are you aware of the labs that were taken, the vitreous labs that were taken and returned by NMS labs in this case?
I did review those, yes.
Okay, and are the testimony that Dr. Molina stated that she could not testify as to when they were placed into the freezer? Do you recall that?
I do.
And that she was also, the lab results show that they were not run until October 30th or after, at which point 2.5 months had passed.
Yes.
Okay, and based on that, would that bring into question whether or not those labs were reliable?
I would say that, especially for glucose, it will degrade over time if it's not properly stored. So if, when I was a clinical fellow, yeah, it was incredibly important for me. When I drew labs for my project, I had to take them downstairs, immediately spin them within an hour and put them in a negative 80-degree freezer so that the labs would be, that the results would be reliable.
And in regards to diabetes, can you rule it out at this point?
I don't think you can rule it out. I just had a low degree of suspicion for it.
And in regards to multifactorial contributing factors to someone's ultimate death, are there other things that could have been going on in addition, if he was starting to have diabetic issues, because he does have elevated glucose levels, correct?
I think he did, like, on the labs that they drew from the IO. I think he had slightly elevated glucose. I'm not quite sure
And
at this point.
the testimony that we have so far is that there was an EMS that took a finger prick and it was 300, and then the labs, the terminal labs at CHOSA were 214. Do you recall
Yes. Yes, and there are many reasons blood glucoses can become elevated. The blood glucose can be elevated from getting epinephrine, especially. It's a counter-regulatory hormone that will cause your blood sugars to elevate at that point, because it's why, like if you get hypoglycemic, why you feel jittery, it's because your body is producing those hormones to try and get your blood sugar back up. And so getting big doses of epinephrine would probably raise your blood glucose, but it would be, that is consistent with diabetes, if you want to say that.
Okay, and, or at least at this point, we can't rule it out, correct?
I don't think you can rule it out, yes.
And in regards to other things that could have been going on, are there other things that you, in conjunction with the possibility he might have had diabetes, even if the diabetes at that stage wouldn't have been terminal, is there other factors that you were looking at that could act in conjunction with that, or other things that could have created an event that resulted in his passing?
Yeah, there were several contributing factors for me. When I saw that he had, one, I don't really see muscle mass loss
Just
to
one
that
second.
degree.
Dr. Gebhardt,
And
just 1 second.
I'm sorry?
Just 1 second, please, sir. I'll let you know when it's safe to resume.
I'm going to object at this point, Judge, that the plaintiff is outside the scope of his expertise. He's testifying essentially as to cause of death.
Your Honor, I don't think he's testifying to cause of death. He's trying to, as a critical care physician, he works with people who do go terminal, and he's saying, like, based on the facts he knows of someone who's alive, what's going on prior to the passing, would that, be something that he would be concerned with that would cause someone's demise or cause their passing?
The objection is overruled. Dr. Gebhardt, you can continue answering the question.
Okay, so things that would concern me significantly for somebody getting close to death. When somebody is incredibly sick, having other factors that play into it is a huge part. So if someone that just comes in with diabetes, that's okay. You come in with diabetes and a tumor or and other issues, then it puts you more and more at risk of dying. And so when you have a kid like Benji, who had really high sodiums, had been vomiting the night before, had not been eating that well, all of those factors can play into electrolyte derangements. If he had predisposing factors like maybe he was more prone to having seizures, he just never had one yet, and then when his electrolytes get off, that causes him to have a seizure. If his electrolytes get off from all of the vomiting, that can also put you at risk for, having cardiac dysrhythmias, which is a very difficult to find on an autopsy of some sort, because you need to see the rhythm on a cardiac monitor before, you can't see that afterwards. So I thought that there were other contributing factors that could potentially have led to Benji's demise.
So it was more the totality of several things going on potentially at once for this young kid that may have contributed to the ultimate result.
Absolutely.
Now, should the parents have known their child was about to expire at this stage?
Judge,
Just 1 second, Dr. Gebhardt. I'll let you know when you can resume. Go ahead.
I'm going to object that it calls for speculations as to what the parents might think.
That objection is sustained. So Dr. Gebhardt, Ms. Sawyer is going to ask you another question.
Well, without being hooked up to monitors and knowing what someone's lab levels are in a particular moment, is there any other way for a parent to know that a child is about to expire?
No.
And
Unless your child is acting in a manner that is concerning to you and you are worried enough, then that's when you go seek care. But if you're not, if your kid has been throwing temper tantrums and they continue to throw temper tantrums, it's hard to tell.
so, do kids die for unexpected reasons?
Did he die from an unexpected reason?
No.
That was my thought.
Oh,
That he expired, not necessarily because of.
Just 1 second, Dr. Gebhardt.
Again,
Sorry.
I'm going to object.
I keep looking away.
He's testifying as to cause of death. So I believe it's outside the scope of his expertise.
The objection is sustained. So Dr. Gebhardt, Ms. Sawyers is going to ask you another question.
okay. And then, Dr. Gebhardt, why did you agree to take this case?
Why did I agree? Because I felt like.
Judge,
Just 1 second, Dr.
Go ahead.
Gebhardt. There's been another objection.
I'm going to object to the relevance.
How is that relevant?
Well, they questioned whether he got paid, whether he, they implied that somehow he's here for reasons that have nothing to do with this case.
The objection is overruled. Dr. Gebhardt, you can answer the question.
Thank you. So I'm a busy guy. I went from testifying yesterday straight to work, and I've been up all night, and now I'm back to testifying again. This isn't something that I consider to be a ton of fun. Going through and reviewing cases where children die is incredibly sad for me. But it is, in this particular case, I felt like it was, I believe yesterday we talked about how doctors can make mistakes. And it seemed like there were people that were trying to go to conclusions that I didn't feel were correct. And that, I think everybody deserves a fair shot. And I thought that it would be unfair for Benji to, have his parents punished for something that they may not have done. And so I thought there was a lot of doubt in my mind about the conclusions. And so that's why I took your call when I was on vacation with my kids. And I was like, okay, well, let me see this through and I'll hear you out. And so when I did, I was like, yeah, there to me are several plausible and probably more likely explanations for this than starvation. That's why I took the case.
Thank you. I pass the witness.
Dr. Gebhardt, do you recall emailing me the last time after you testified, and you sent me that email around April 15th of 2024?
Yes.
Okay. In that, you told me he does not have type 1 diabetes, he being Benji, correct?
I did not think he had type 1 diabetes.
Okay. Ms. Sawyer's talked to you about other contributing factors that you think may have been in play. What evidence do you have or do you review relates to a contributing factor?
So when I was reviewing it, I saw that when I read through, I didn't know why she commented on cerebral edema if it's a normal finding on an autopsy. So when I saw that he had cerebral edema, it to me was like, okay, I don't that can be a contributing factor. It can be why someone's sodium jumps up so high. When you have brain swelling, it can cause you to have the pituitary get cut off, and you can have massive losses of urine at that point.
Okay. But
If you have a heart, if you've been vomiting all night before,
Dr. Gebhardt,
then,
Dr. Gebhardt,
yes, sir.
so I want to take this a little piece by piece. So I want to talk about
Please.
the cerebral edema for a second. You're aware that that is a common finding in autopsy, correct?
Yes.
Okay. So, as it relates to, finding that in any type of death, that's not abnormal, right?
I'm sorry. My dogs just came in. And I missed what you said. Could you please repeat?
I sympathize. As it relates to the cerebral edema, that is a common finding, correct?
Yes, sir.
Okay. And you would agree with me that that's not his cause of death?
I would not agree with you as to that not being his cause of death. If it is a common finding, I don't know why, like when I find normal things, unless it is pertinent in my practice, if someone comes in and has last night, if someone has a brain tumor, I'm going to do a neuro exam, and I'm going to document everything that's normal so that if something changes, it's noted. But beyond that, I'm not going to try and document a ton of normal findings in my note. And so when I saw that cerebral edema is present, okay, why are you commenting on that? She also noted that there was a globular heart. Sorry, go ahead.
So there's a lot of things noted in there, right, that are quite frankly very normal, correct?
Yes, the normal glistening of the kidneys, the liver, the normal organs that she saw.
Okay, so it's not fair to say that she just put in there the abnormal finding. It's essentially all of her findings, right?
It is all of her findings. It just seemed to me to be odd that she noted cerebral edema.
Okay, and so, I mean, the argument would be on the other end, right? So if there wasn't cerebral edema, well then why didn't you put that it was cerebral edema, right? So the fact that it's in there doesn't mean that it's a contributing cause of his death. Fair to say?
Sure, you can say that.
Right, and cerebral edema, it kills you when it causes a herniation in the brain, correct?
Potentially. It can also not kill you, but it can cause you to have, I treat people with cerebral edema all the time, so it doesn't necessarily kill you, but if you're not treating it aggressively, it can kill you, and it can cause a lot of derangements with your hormones and electrolytes.
Right, but the edema, the cerebral edema, as that being the cause of death, that does not happen until it herniates, right? It goes outside of the skull, essentially. It has to go down towards the...
It has to cut the blood supply off to the brain, yes.
Right, so that's the point, right? So, in this case, in the review of the evidence, did the cerebral edema cause that restriction in the blood flow to the brain?
I don't think it did.
Okay.
So, but as a contributing factor, it can cause the derangements that cause other things to happen. He looked like a sick little boy.
Okay, so he did look like a sick little boy.
Yes, he died, so yes.
Okay, did he look like a sick little boy prior to that in the photographs that we showed you?
He didn't seem all that, like when he's crying in the back of the car, I didn't think, to me that doesn't seem like a kid who's going to arrest in a few hours.
What about the photograph where you can actually see his entire body and he's just standing drinking, has a water bottle in his hand? He doesn't look like... He looks, like he's pretty skinny, but I don't think that that's a kid who's going to arrest in a few hours. Not my question, sir. My question to you is that does it look like a sick kid in that?
Does he look like a sick kid? Granted, my view of what sick actually looks like is
Just one
very
second.
skewed by what I do.
Dr.
But,
Dr. Gebhardt, just 1 second. Ms. Sawyers.
I'm gonna object because he doesn't have enough information. A photo alone does not indicate whether a child is sick or not sick.
I'm going to overrule the objection. Dr. Gebhardt, you can continue answering the question.
So I can tell from, there are some kids that just look, obviously jaundiced, obviously edematous, like they're in heart failure. Kids, you can tell from photos of what kids could look like. He looks like he's skinny, and if you're gonna say that that's how sick he is, but he looks like he is, like he's had some weight loss, but not like a ton of weight loss, and he looks like he has some muscle mass, and he's drinking water in a diaper.
Okay, and so what did you say, he looked like a sick kid then?
I would not say he looks like a profoundly sick kid.
No.
You can say he looks sick, sure, but I wouldn't say profoundly sick.
No, I guess my question to you, prior to that, you said, he looked like a sick kid, of course. What were you referring to?
The fact that when I say he looks like a sick kid, he died. And so he's obviously a sick child. Why he arrested, I don't know, but I guess I misspoke in saying he looked like. He was obviously a sick child.
Okay.
And so when you don't do autopsies on people that are healthy.
Fair to say, you've never done an autopsy, right?
Have I ever done an autopsy?
Correct.
Okay, no, I have not done an autopsy.
And so, going back to Dr. Molina's report, you're relating it to your clinical experience, what you would expect to put in your report, right? So that's...
Yes.
And so, you would agree with me that she has a different function than you?
Yes, she is a forensic pathologist who sees dead people.
Right, and she has a different expertise than you?
Yes.
And that, essentially, especially in this case, where initially Benji's death was unknown on August 17th of 2021, don't you think it would have been important for her to document the findings, whether they are normal or abnormal, as it relates to her autopsy?
Yes, she should document them as normal in appearance, but she did not say that they were normal in appearance. She just noted that they had their cerebral edema present. Oh, okay, that's my point.
Okay.
When I document normal, I say, there's no adventitious breath sounds or there's normal heart sounds.
Well,
So I preface things with normal.
if she would have
But
put,
she might not, and that's okay.
if she would have put that the brain was normal, but it did have edema, would that be accurate then?
If it's what she expects to see on an exam, then I would say that that's what you could say as normal.
So, as it relates to normal, your understanding of what she should have done is essentially, if it's normal with it, then just put normal, don't make any notations out to the characteristics.
In my mind, that's what I would do. But she's her own person, that's fine.
Right.
And when we talk about having different expertise, I think you told me that I don't have the ability to go through different labs as well, or know about vitreous labs and stuff like that. And I was just wondering, we're all in medicine together. And so, yes, she is a forensic pathologist, but we do see very similar patients. And I also do put causes of death on people when I sign their forms.
Right, you make causes of death when it's known at the time, right?
Yes, once if they've been in the hospital for over 24 hours, and we have a known cause of death that is, or we're willing to say that we know that the cause of death is, that's when we will sign it.
Right, so you don't do unknown causes of death.
That is correct.
Right.
Or any traumatic injury that happens.
And by law, you can't even, as it relates to if somebody dies unknown in the hospital, you can't sign those death certificates.
Yes, I would be unwilling to sign an unknown cause of death.
Because that's the medical examiner's job, is to make that ultimate determination.
It is their job to do that.
I'll pass it to Trish.
Yes. first, when you made the statement that the type 1 diabetes was, that you did not believe it's type 1 diabetes, you did not know at that time that the NMS labs may not be accurate, and that the beta hydroxate and the acetate, I might have gotten the third one wrong, were not tested, correct?
The acetate and the beta hydroxy, I did not find those labs anywhere, and I did not know about the labs and exactly how they were stored.
And so now, would you agree that without those being tested, we don't have the data at this point to be able to determine what his levels were on his passing? Yes, you would not know that. Okay.
I agree.
And then my second question is in regards to cerebral edema. It seems like you were trying to explain that when someone has a cerebral edema in your practice, there are certain things that it indicates. And what are the things that it indicates to you in a living patient that would affect this case?
So when you have cerebral edema, again, it can cause you, it doesn't necessarily have to kill you to cause problems. In people that get cerebral edema after a car wreck, they can have edema that will swell just the top part of the brain. And so if the top part of the brain is, the part that you think with and have most of your, ability to process information, that part of your brain, if it's injured, will be out, but the brain stem itself, where you have most of your vital functions like your blood pressure, breathing, those types of things will still be intact. So you can still have cerebral edema and issues with your pituitary that will start knocking out different hormones and causing you to have issues like peeing too much, diabetes insipidus, having issues like that.
And those issues could result in something else going wrong in the body that causes your body to expire?
Absolutely. If you pee, and potassium excretion from your kidney is directly proportional to your urine output. And so if you're not getting a lot of potassium in, or you're throwing up a bunch and your kidneys are trying to hold on to a bunch of sodium, they will kick out a bunch of potassium, and you will have, big shifts in your potassium and big shifts in your sodium, and you will have your cells unable to maintain their electronegativity in the way that they should, and you can have heart dysrhythmias from that.
And
You can have seizures from that.
Would a heart dysrhythmia, can it kill you?
Absolutely.
I pass the witness trial.
Just very brief, Judge. Diabetes insipidus, that's not type 1 diabetes, right?
That is correct.
Okay. That's not what we've been talking about almost for a large part of your testimony today. Two different things, right?
Very different things. They both make you pee a lot. Diabetes insipidus is just a loss of your antidiuretic hormone, which is secreted by your pituitary, that keeps you from peeing out water all the time. If you lose that, you just pee out water, basically. And you can get very dehydrated and have really high sodiums from that.
No further questions.
No further questions, Your Honor.
May this witness be?
Yes.
Yes.
Dr. Gebhardt, thank you very much for your time and your testimony. You are excused.
Thank you.
Thank you. Ms. Sawyer?
At this time, the defense rests.
Mr. Vieira?
The state would rest in peace.
And we rest in peace.
Ladies and gentlemen, you have heard all of the evidence and testimony in this case. It is now necessary for the parties to meet and confer on the charge of the court. I am going to give you a break about 20 minutes in length. I'm going to give you an opportunity to get what you need. After we return from the break, you are going to hear the charge of the court. You are going to hear closing arguments from both sides, and then you are going to begin your deliberations. Once you begin deliberations, we are on your schedule. We wait for you to deliberate and return a verdict. I'm going to let you go back to the deliberation room. Deputy Guajardo is going to have a couple of more instructions and information for you. We'll call you back in about 20 minutes. Thank you.
All right, the jury.
Ladies and gentlemen, I apologize for the delay. Thank you for your patience. The charge of the court is both a complex part of trial and it is extremely important that it be done correctly. And this is the charge of the court. In 2022 CR 4915A, the State of Texas versus Brandon Cervera, charge of the court. Members of the jury, the defendant Brandon Cervera stands charged by indictment with the offense of injury to a child alleged to have been committed on or about the 17th day of August 2021 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of injury to a child if the person intentionally or knowingly, by omission, causes to a child serious bodily injury. 2. An omission that causes serious bodily injury to a child is conduct constituting the offense of injury to a child if the actor has a legal or statutory duty to act, or the actor had assumed care, custody, or control of the child. 3. A parent of a child has the statutory duty under Texas Family Code Section 151.001A2 and Section 151.001A3 to care and protect the child, and the duty to support the child, including providing the child with food and medical care. For purposes of an omission that causes serious bodily injury to a child, the actor has assumed care, custody, or control if the actor has by act, words, or course of conduct acted so as to cause a reasonable person to conclude that the actor has accepted responsibility for protection, food, shelter, or medical care for a child. 4. Child means a person 14 years of age or younger. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Omission means failure to act. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 5. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. But the date of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by the statute of limitations. The statutory limitation period for the offense of injury to a child is 10 years from the 18th birthday of the victim of the offense. The indictment in this case was filed on May 19, 2022. 7. Our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, or aids or attempts to aid the other person to commit the offense. 8. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, you cannot find the defendant, Brandon Cervera, guilty unless you believe beyond a reasonable doubt that the death of Benjamin Cervera would not have occurred but for the conduct of the defendant. So that if you believe that the conduct of Miranda Casarez alone was a concurrent cause sufficient to cause the death of Benjamin Cervera, and the conduct of the defendant was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. 9. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 17th day of August 2021 in Bexar County, Texas, the defendant Brandon Cervera, either acting alone or together as a party with Miranda Casarez, did intentionally or knowingly, by omission, cause serious bodily injury to Benjamin Cervera, a child who was 14 years of age or younger, and Brandon Cervera, either acting alone or together as a party with Miranda Casarez, had assumed care, custody, or control of Benjamin Cervera and failed to do so in that Brandon Cervera, either acting alone or together as a party with Miranda Casarez, failed to provide adequate nutrition for Benjamin Cervera, failed to provide adequate hydration for Benjamin Cervera, or failed to seek proper medical care for Benjamin Cervera, or did intentionally or knowingly, by omission, cause serious bodily injury to Benjamin Cervera, a child who was 14 years of age or younger, and Brandon Cervera, either acting alone or together as a party with Miranda Casarez, had a legal or statutory duty to act and failed to do so in that Brandon Cervera, either acting alone or together as a party with Miranda Casarez, failed to provide adequate nutrition for Benjamin Cervera, failed to provide adequate hydration for Benjamin Cervera, or failed to seek proper medical care for Benjamin Cervera, then you will find the defendant, Brandon Cervera, guilty of the offense of injury to a child as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Brandon Cervera, not guilty of the offense of injury to a child as charged in the indictment. 10. It is a defense to this prosecution that the actor, through mistake, formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for commission of the offense. The term reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Brandon Cervera, committed the acts alleged, but you further believe, or you have a reasonable doubt thereof, that at the time of the alleged acts, he had, through mistake, formed a reasonable belief about a matter of fact, to wit, that Miranda Casarez was providing adequate nutrition and adequate hydration to Benjamin Cervera when Brandon Cervera was not present, and that following the medical advice of the medical professionals at Little Buddy's pediatric clinic was sufficient regarding the proper medical care of Benjamin Cervera, and that said mistaken belief negated the culpability required for the commission of the offense as defined in paragraph 9 of this charge, you will find the defendant not guilty. But if you believe beyond a reasonable doubt that the defendant, Brandon Cervera, had not, through mistake, formed a reasonable belief about a matter of fact, to wit, that Miranda Casarez was providing adequate nutrition and adequate hydration to Benjamin Cervera when Brandon Cervera was not present, and that following the medical advice of the medical professionals at Little Buddy's pediatric clinic was sufficient regarding the proper medical care of Benjamin Cervera, or that such a belief did not negate the kind of culpability required for the commission of the offense as defined in paragraph 9 of this charge, you will find against the defendant on this defense. If there is any evidence of another act or other acts of misconduct by the defendant against the complainant in this case not alleged in the indictment, such evidence is not to be considered unless you believe such act or acts, if any, were committed beyond a reasonable doubt. With regard to such other act or acts, if any, you are instructed that said evidence was admitted, if it was, only for the purpose of showing the state of mind of the defendant and the complainant and the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify. You are instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must find the defendant not guilty. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include but not limited to Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone any information or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. You are instructed that you are not to let bias, prejudice, or sympathy play any part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But the law of the case you must receive from the court as contained in these instructions and be governed by them. You must disregard any statement or comment made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was intended. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify your verdict by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. A unanimous vote means all 12 jurors must agree. The forms are not intended to suggest to you what your verdict should be. If, during your deliberations, you request that testimony be read back, under the law, testimony cannot be read back to you generally. Before the court is allowed to read any testimony back to you, you must have a dispute about the testimony that you are asking about, if you are, and if so, you will need to specify exactly what you are in dispute about. If you have a disagreement about a certain witness's testimony and you specify as to what you are in disagreement about with regard to the statement of any witness, then you may, upon application to the court, have read to you from the court reporter's notes just that part of such witness testimony or the particular point in dispute and no other. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, they shall notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Christina Escalona of the 186th Judicial District Court. Ladies and gentlemen, there is a verdict form attached to this charge. It is there for your convenience. I do ask, if you do decide to use it, you do not have to use it. If you decide to use it, that the presiding juror sign under whichever verdict applies and cross out the verdict that does not apply. I do want to make a note as well, outside of your presence, there were exhibits that were withdrawn from admission by the agreement of both parties. So we can send you all of the exhibits and items of evidence that were admitted. If there are items of evidence that are missing, it is because they were either not admitted or withdrawn by agreement by the parties. With that, I will turn it over to the state of Texas.
Thank you, Your Honor. So, a father is more than a breadwinner. A father is more than a disciplinarian. A father is a protector. And that's not just the standards that we set in society, although it is. It's also a legal duty imposed by the state of Texas, right? To all fathers and to all persons who take care, custody, or control of a child, right? So, if the defendant had abided by that duty, we wouldn't be here today. But since we are, it's my job at this point in the proceedings to kind of recenter your focus on what it is that you, as the esteemed juror members who are deciding what the facts are in this case, what is really at issue that you have to decide. Because some of the things of the entire universe of things that the state might have possibly had to prove before the case started, the universe of what we actually are in dispute about is very small, right? So I'm going to show you, this is paragraph A, right? These are all of the elements that the state has to prove. Most of these are not contested, right? August 17th of 2021, that's the date Benjamin died. We know that we're talking about that day and the year or 10 months preceding it, right? We're not unclear about what person we're talking about when we say the defendant, the father of the child, Brandon, right? Intentionally or knowingly is in dispute. I'll talk about that more, and Mr. Villarreal is going to talk about it more. I expect Ms. Sawyer will also. By omission. What we're saying by omission is we are establishing the distinction, right? When you have a duty to do something and you do nothing, that is an omission. So we are talking about not actions that were done, but failures to do actions, right? Caused serious bodily injury. Now, there is some dispute here. Obviously, Benjamin died. That would be included by serious bodily injury. But that is not the extent of what you are to consider. Because you are to consider all potential serious bodily injuries, including those suffered by Benjamin before his death, based on the failures to act by the defendant. So it's not just death, it's SBI, serious bodily injury, the impairment of any bodily organ. That could include things like failure to thrive, stunting. Who we're talking about is not an issue, right? Benjamin Cervera, very clear who that is. Assumed care, custody, control of Benjamin Cervera, and by failing to do something, the three things, right? Adequate nutrition, adequate hydration, proper medical care, right? It has to be the failure to do one of those three things that causes a serious bodily injury. Compare it to paragraph 2. Really the only difference here, if we look, going back from A to B, it's just that now we go from care, custody, control to statutory duty to act. That is empowered, that is required because he is the father. So the first is saying, he, like anybody could, takes care, custody, control of the child. He is now responsible for its medical care, for the treatment, the food, the water, right? Compared to legal duty to act, when you are the father, you always have those duties, right? Okay. So, what I want to focus on is the intent. And what I think you can conclude from looking at the evidence in this case, oh, I'm sorry, very important. You don't have to agree as to if it's intentional or knowing. You all just have to agree that it was one of the two. You don't have to agree on the injury, just that there was serious bodily injury. And you don't have to agree on which of the manner and means, by failing to provide hydration, by failing to provide medical care, by failing to provide food, nutrition. It is only if all of you find one of them, right? So you could find that you believe he intentionally withheld food and that caused the death. That's a guilty verdict. You could find knowingly withheld medical care caused SBI, not death. Also still guilty. The fact that the two of them are different injuries, different instances, and different causes, all that matters is that he had a duty to act. His failure to act caused the serious bodily injury or death by one of those three means, right? So if we're talking about the intent, I believe that the evidence in this case proves that it is an intentional deprivation of food, medical care, and hydration. Why do we know that? Look at the apartment. Everything that we know about the apartment. The first thing that we know, right, is that cameras are installed to view the children and the kitchen. And these aren't security cameras we're talking about in the sense of there's not one outside watching the entryway to the home. There's not one pointing at the door, the only entry. There's none pointing at the windows to enter, right? Where are the cameras? The children's room, the kitchen. There's one in the living room. Where does it point? Down the hallway to the kids' room, right? Why are those cameras there? Why were they placed there? Is it not to monitor the children? Monitor the children because you think that there may be something wrong. Something that, for example, you might have wanted to consult a medical professional regarding. Well, these cameras are here at the beginning of June. It's not until CPS makes them take him to the hospital on the 21st of July that he's sent to the hospital after the cameras are installed. And what do we know about those cameras, about what is present in the home, right? Once the cameras are in place. Well, I don't know why the pictures aren't working. Here's what we know about them. The beginning period in June, right? The cameras are in place. What is on the locks? What locks are present? There's that little plastic internal lock that's in the cabinet, right? There's a similar lock that's on the refrigerator. That right there is proof of intent to deprive food. Like, I am intentionally restricting the amount of access that he has, right? And I'll remind you, those two my understanding. So,
Does it?
Thank you. Yes, it definitely does. I'm so sorry. Hold on, Jody. Oh, that was exactly what it was. That's what the problem was.
All right, thank you, Your Honor. Please the court. So, guys, this is a tough case. I mean, whether you have a child of your own or you don't, it's always a tragedy when a child dies. The tragedy was compounded here, though, by what was failed to be looked at. Because everybody was so eager to tar and feather and brand that they didn't go look. And so you, the 12 of you, are the first people that ever went to go back and look and listen to Benji when he was alive. You were the ones, not Detective Size, not Dr. Molina, not even these prosecutors were focused on that. I was made sure that you heard what he was saying. Because what we don't know when we don't go look affects the big picture. Now, I understand the state has these very sensational tidbits that they're giving to you, and they make for great sound bites and they make for great media stories. But at the end of the day, it doesn't bring Benji back, and it really doesn't help you get to the truth. Because in order to get to the truth, you have to go look for the truth. And this is what Brandon saw when he saw his family. This is what the media is not saying. This is what we need to be focused on. There was a happy family here, and by all indications, as you can see, it was a family unit. Now, are families perfect? No. Not a single one of us is perfect. We have all said or done stuff to others or even to our own children that it can be mistaken or taken out of context. That does not mean that we did not have or come from a good spot when we said it. When I think about this case, it, to me, is difficult because I can see the care and the love that is there. This is not the typical type of place that you're going to see when you see a place where people are abusive and negligent and don't care. I mean, there are matching beds for the boys. There are posters on the wall. There are matching shirts. This is someone who cares. And all the indicia of what we think of when someone cares is nesting. And you know, we're gonna talk about Miranda here in a little bit because it's hard for me to get a grasp on some of the things at the end. And so, as you're gonna become aware, and you've heard in the testimony, they had a new baby that was born in January of 2021. Then they moved in March of 2021. And she was nursing up all night. I don't know if she had postpartum. She didn't appear to be the type of monster that would do anything to Benji. So we need to take that into consideration, but that doesn't mean that mental health-wise, people can't reach a breaking point that would make them do something they wouldn't normally do. We'll talk about that in a little bit. All right, the state really wanted to talk a lot about the photo on the left, but I want to show you that what we tend to see when we look at all the pictures from April 4th, which is the photo they're focused on, to April 26th of 2021, to July 26th. This is the picture on July 26th. He's going to Little Buddies. This is what he looked like. Healthy, appearance, we understand that you're gonna see, and you did see, the bruising on his eyes. The reason I played that video for you on July 20th, 2021, is so that you could hear Benji, because he was being asked about every little thing on his body. And through his own words, he was able to tell you what happened. His dad was not sitting there. His dad was not telling him what to do. I disagree with what the state sees when they see that video. What I see when I see that video for the welfare check is that Brandon sits back and lets his children talk. He doesn't overspeak them. He doesn't interrupt them. When Officer Hale says, "Hey, what's that bruise?" It's on this side, on your hip. Benji's like, "Where? And he's trying to find it. Brandon doesn't interrupt. Brandon doesn't say, well, tell him what you did to yourself there. No, he doesn't do anything. He stands back and he lets Benji talk. And then finally, the child immediately starts saying, after he figures out what they're looking at, he's like, "It's my diaper." And he says it like 8 times. They said they couldn't understand him. I understood him. I don't know, maybe I speak mommese. But I understood what he said. And he was saying diaper from the very beginning. And it was right where his diaper line was, and it made sense. So, nevertheless, the point is that when you also look at that video, you will see that Brandon is acting like a normal parent. If I was speaking to a police officer and my child was asking me to go do something else, and I knew that that police officer needed to speak with me or the child, I wouldn't be running off and distracting the child and going and doing other things. At that point, Brandon was focused on making sure that the child was there and available to speak with the officers as well as to be cooperative. I think it's really important that we not take things out of context, because I believe that we would do the same thing if we were in Brandon's shoes. And the fact that he said, "Hold on, wait a minute," he didn't say no. He was like, just wait, not right now. He was waiting for that moment to pass. And telling a child no does not mean that you're depriving them of food. Here's the thing. We have, as parents, an obligation when we're working with our kids to try to teach them wrong from right and routines. And we know sometimes more than they do because they don't want to take naps. They don't want, maybe they want to eat something that's not so healthy for them. And in doing that, they eat something that's not healthy for them, then they will not eat the things they actually need to grow healthy and strong. And so there is this balance that has to be met when we work with kids. And I think that it's unreasonable for the state to come in here and act like any time a child is told no, that somehow indicates child abuse. That somehow is some, deprivation of a need. That is not what was going on here. All right, so we have the court charge. We'll go over that you have a legal or statutory duty, that someone who has a legal or statutory duty to act, whether that's as a parent or because you just took care, custody, and control of a child, you do have duties, and you have a duty to provide food and medical care. All right, nobody disagrees with that. What we disagree with is when you have to, first, in order to be found guilty of this charge, it would have to be shown that Brandon Cervera intentionally or knowingly caused serious bodily injury to Benji by failing to do something. Now, when you see in the wording, and it's going to say by adequate nutrition, by adequate hydration, by proper medical care. That's not the duty, that's just how the state's alleging that the duty was violated, right? So the duty is food and medical care. The problem I have with adequate nutrition is that each and every one of you would agree on what is adequate nutrition, right? Because we disagree on what nutrition is. So when you go back there, I want you to think about what Dr. Lukather did say. He was like, it's not about the quality, it's about the quantity, right? He was talking about the food. And so that makes more sense that we are judging people by making sure there's food available. And I'm going to explain to you why, when you look at this case, you're going to see that food was available and made available, and that this whole thing about bread that the state is focused on is actually, you're going to see how much bread he was eating in one of these photos. They won't present it to you like that. They'll present it to you to demonize my client because he's saying, don't ask for another whole loaf of bread. The child had just eaten a whole loaf of bread. If I were a parent and my kid had just eaten a whole loaf of bread, I would be also telling my kid, don't ask me for another whole loaf of bread, you just had one, right? But it's taking it out of context. So, when we talk about adequate nutrition, I really need you to be careful here because we engage in a slippery slope of what's adequate. The child was not starved. You have heard from multiple experts. You've heard from Dr. Christensen. You've heard from Dr. Gebhard. I mean, this child, while small, he was always small. And that does not make someone starved. Adequate hydration. You heard from Dr. Molina. You can just check that off of your list because she said this child did not die of dehydration. So I don't even know why it's even alleged. But we'll get into that in a little bit. Proper medical care, and you're going to see the term proper in there. But here's the thing, guys. If you go to an ER, your pediatrician, your ENT, you're not going to a quack, you're not going to this healing arts, at that point, you have to be able to rely on the people that you're going to. Otherwise, it is an unreasonable burden on our society to start trying to figure out which doctor is better than another one. When you are taking your child to the doctor, and it's the doctor, the type of doctor that the doctor you went to told you to go to, you can rest assured that that should be enough for proper medical care if you're following those directives. At the end of this, the state has to prove each one of these beyond a reasonable doubt, and I do not believe they can prove any of them. We just talked about the legal or statutory duty to act. Intentionally or knowingly. Now, he has to have intended to cause the harm by the starvation and dehydration and medical care, by failing to do it. Do you see? It's not just that
I object at this point to misstatement of the law. It's intentionally or knowingly.
What did I apologize. Intentionally or knowingly. I was not trying to leave out knowingly if I did. But the point here is that you have to intend the result or know that the result would happen, right? And so it's not enough, even if, first off, I don't believe they can prove starvation, dehydration, or lack of proper medical care. But even if they did, you have to go further than that and find that he was doing so intentionally or knowingly so that this child would suffer serious bodily injury. Serious bodily injury creates a substantial risk of death, or that causes death, causes serious permanent disfigurement, or results in the protracted loss or impairment of the function of any bodily member or organ. Again, with the exception of Dr. Molina feeling that or claiming that the child died of starvation, that is a death, right? So that would, if it were in fact that you found that would be a death, would qualify under serious bodily injury. But if the child just died, that alone does not qualify. It has to have been caused by something, right? Like that they're claiming, like the starvation or dehydration or the medical care. So if the child passes and he passes for any other medical complication, that doesn't mean you brand someone a criminal and throw them in prison for up to life. That's not what we're here for. You need to be focused on the fact that the serious bodily injury has to relate to the starvation, the dehydration, or the medical care. And we saw no organ failure, we saw no permanent disfigurement, and so I do not believe that those would qualify here. All right, failing to provide, we talked a little bit about that already. Welfare check. All right, so what do we see when we see this picture? Because Officer Taylor, in his body-worn camera that I showed to you, said, here's my SAPD number, keep this number and give it to anyone you go to, because this case number, you'll need it, because anyone who sees this kid would not think, he looked bad, and they would think that you have done something. And so you need this SAPD number so that they can reference back to this welfare check where we have talked to the child, we've looked at everything, and even though he has the black eyes and the ears going on, that nobody's gonna misunderstand that because we have looked into it. And so I found it telling because Officer Taylor was foreshadowing the problems that were about to happen. And the problem started when you have a detective size who does not go back and look at all of the evidence, right? Because if he had listened to little Benji when he was talking, we would not even be here today. We have buccal fat, as you can see. The bruising on the eyes is consistent with him having done it to himself, because if you're getting hit, you don't get hit symmetrically where you have bruising on both eyes like this generally. Also, you can see the musculature of Benji's arm, and we also, in the photos that we showed regarding his leg and how it came up, if you'll remember, when they were describing the muscularity of an individual, and we have, it's not concave, right? We have, it's going over. There is a quad muscle there. The quad muscle would have to be gone in order for us to even be at the stage of lethal starvation or serious bodily injury from starvation. And so when you look at these, the photos themselves speak volumes, right? It does speak volumes. It's telling a story. Locks are unlocked. Now, oh my gosh, I'm sure when you leave here, you're probably never going to want to hear the word locks again. We have heard locks a lot. But the reality is that I know as a parent that I've done a lot of, thought, oh, I'm going to do this or I'm going to do that for a kid, and then when I start to implement it, it just doesn't work. It's not helpful, and you don't go through with it. I'm not saying that they weren't concerned initially, but Benji was able to get in. The fact that they exist does not mean that they are frequently used. But here's the thing, if you have a child who is voraciously eating to the point that you're concerned about them choking and you need to sleep, you're not trying to deprive them of food. You're trying to make sure that you have put on your face mask first, right? When we were in an airplane and they tell you when if it drops down, put on yours first and then your child's. Well, here's the thing, when you don't get sleep, you can't take care of kids, right? Because you do need to get some sleep. And if you're always up watching and worrying about them, they can get hurt, but you are also hurting the family by not being healthy enough to be able to watch them. So the point is that, just because locks are present does not mean that that's actually keeping a child from food. Generally, when we think, starvation cases are so rare in the United States that every single person that testified told you they had seen one, two, with the exception of Dr. Gebhardt, okay? But they don't see them. because they don't happen that way, because when people are out and about, you would be able to pick out someone who was that starved. You would see the bone. You wouldn't see this curvature. I mean, it would be a bone, you would have a knuckle, and that's what we're talking about when we get to that serious bodily injury. There's food all in the apartment. Clearly, there is no desire or intent to withhold food, and you have 3 other children in the home that are also eating and happy and healthy. So the fact that you have one kid that's struggling a little bit more, but has always struggled, you may not realize it in that moment, because you see them as being small always. So there's food. Now we wind up at CHOSA. First the Pearl ER. If you look in the records, I believe they go to the Pearl ER first, and that is for the ear. They go, that is not with the intent from CPS. Then they go to CHOSA, and he's checked out head to toe. It is disingenuous for our government, our state, to sit here and say that, oh, well, they didn't go there on their own accord, and that it's so bad that you need to brand his father a criminal for starving him, when they themselves had him checked out head to toe and found that there was nothing wrong with the nutrition that they felt that they needed to address. And at that point, he was 13.84 pounds. Sorry, kilograms. I apologize about that. You know, this case is a very scary case, because if you think about the precedent it sets, because if you are doing everything you're being asked to do and you're taking your child and you miss something, man.
I'm going to object to improper argument.
They were looking for child abuse. It wasn't as if the parent took the child in on their own volition and said, hey, he just has an ear problem. Can you just check the ear? That's not what happened. If this child was in danger and they even mildly suspected it, they had a duty to report and to take action. And they took action. They took action in saying, hey, instead of like, we're going to check you out. We don't find that there's been child abuse. We're not taking the children away. We're going to now refer you to Little Buddies or your pediatrician. Follow up with your pediatrician. Follow up with an ENT, and then they said look at behavioral specialist as well as a geneticist, none of which has to do with food. Then we go to Little Buddies. Here's what you haven't seen, because I didn't have anyone speak to this, but you can see that in Little Buddies on 7/26/2021, they are informing the pediatrician he was asking for bread and got mad because he didn't get more bread. Stepmom and dad were trying to give other options for food choices. He did not want anything other than bread, and he started throwing tantrums, banging head against the bed. The next morning we found him with his eyes looking like that. I mean, they're talking to them about what they are experiencing. And the state wants you, has implied over and over in the evidence that the parents weren't telling these professionals what was going on. The plan is at the bottom. The plan is for the ear that's ruptured, a decongestant, and consider ear drops. Nothing in that plan said anything about, hey, let's talk about weighing the kid. Little Buddies, Dr. Luis Lopez had seen Benji now twice. He had seen him for his well check in December of 2020. And he saw him here. So they weren't taking him to a different pediatrician. They were trying to continue the care. They're not running, they're not hiding, they're doing everything they're asked for. I don't know what else we can ask from a member of our society. Measurements. Now, this picture was taken August 9th of 2021. He's wearing jeans. The state wanted to make a big deal about, do you wear jeans in September of 2020? do you wear jeans in September? And I'm like, I don't know, sometimes you do. I do. I don't like to go around in shorts. You'll never catch me in shorts. But the point is that we don't know when we're measuring these things. And so when you look at even Dr. Christensen's, his chart, he took the data that we have. He would agree, everybody agrees that the data that we have is difficult because the heights are crazy. 99 centimeters is actually 39 inches. That's what it converts to. And so my guess is that when you see these centimeters, the reason that they're off is because Benji was probably 38 something, and they just rounded off to the 99 centimeters. They're rounding it up to 39, and when they convert it to the centimeters at the 99 centimeters, now you've got this big jump between 94 centimeters, which may have been 38 and some change, and then you have as opposed to the 39. And so you'll go from it'll go from 99 to 94, back up to 99 to 95. But what you can see there, though, is that if you look at it, the trend is that he did grow. He grew from his 4th birthday. So it's really hard. As Dr. Lookover said, there is no evidence right now of stunting because we don't have these accurate measurements. That is not Brandon's fault. That's just the facts that we have, okay? And it's no one's intention. Also, as you heard Dr. Gephardt said, we don't know if someone pooped, peed, if they had shoes on or not, the accuracy of the scales. And as I mentioned, the conversion from pounds to kilograms can cause problems, as well as inches to centimeters. Vomiting and urination, loss of fluids. Okay, so Dr. Gephardt talked about this, that when we have when we've lost fluid, it doesn't mean we're dehydrated to the point of death or that we're having serious bodily injury. But when we're dehydrated, if you come into the ER, they know how to calculate how much volume of water they would need to put into your body to put your body back in balance. And that's how he came up with the 0.08 liters. 0.08 liters, he told you, which is the weight of 1 liter bottle of water. It's the 1 liter bottle weighs 1.08 kilograms. And if you add that to the weight that Benji was at the time he passed, he's right back up at that 13.78 kilograms. So it's possible that we are here on something that really had nothing to do with anyone's intent to starve or dehydrate a child. It's just something that the child was experiencing through vomiting, through frequent urination. And so we need to keep that in mind. Let's talk about the August 12th text messages. So here's what they say. I don't want you to call or anything, but man, this boy is out of hand, has been crying all day for bread. I gave him some and he wants all of it. Brandon responds, just give it to the dude. He can just eat that and that's it. Sorry, just chill out. He wants the whole thing. I'm sorry, that blue one that says he wants the whole thing is actually Miranda. He wants the whole thing. And Brandon responds, just give one by one. That sounds reasonable, right? Because we're saying, don't let him choke. Don't let him eat so quickly that he gets choked. And then he don't need to eat dinner. They are fighting over if he eats bread, he won't eat dinner, right? That's the contention that they're having. It does not mean he can't have dinner. It's just that she is saying, no, if he eats the bread, then he won't eat the dinner. And they're getting into this discussion about trying, I guess the frustration or the conflict many of us have on what food should be fed to a child. And then you hear him say, or her say in the text, she doesn't say it, but she's texting it. This is just too much, him getting his way all the time and still not listening. He just finished one loaf, and once more, he's still yelling and crying. And Brandon responds by saying, just give it to him till he throws up, take videos of him. Because if she's so, at this stage, he's saying not that he wants his child to throw up, but the point is that it captures the very behavior that they are concerned about, that he will eat until the point at which he throws up because he's eating so much. Right? It's not that you have to make sure that you're keeping it in the context in which it is written and how they are trying to communicate. I don't even have storage anymore from all the other videos I have of him. And he's like, well, then just delete some. But the point is like, this should not be an argument. If he wants bread, give him bread. If he's eating it so fast that he's making himself throw up, well, then that needs to be documented so that we can show somebody what's going on. All right, catch 22, the bread. Give him the bread, you're a bad parent. Don't give him the bread, you're a bad parent. Because if you look, remember when we talked about kwashiorkor and marasmus? And I had those and I wrote them out for you, and I made sure to say, Dr. Lucifer, which one are we talking about? And he said, we're not talking about the one with the big tummy. We're talking about, which is kwashiorkor. That's the ones that the kids in Africa have. Do you remember that? He said, we're focused on the marasmus because in marasmus, it's the lack of getting any food and you're concaved, right? You don't have anything. I want you to look here. He's just eaten a whole loaf of bread. Look at his distended belly. You know, that's what, they're observing this behavior and can't explain it because we haven't had a child that's been in that situation. But that doesn't mean it wasn't happening, and we can't assume it wasn't happening. Because the only presumption here is a presumption of innocence. And so it is the state's job to prove beyond a reasonable doubt that that behavior wasn't going on. And guess what? They've been involved since July 21st of 2021 and had every ability during that time point to prove to you beyond a reasonable doubt that this kid was being starved, but they didn't do that because all it would have taken would have been to say, hey, let's put him in the hospital, let's give him some food, let's see what's going on. You know? I mean, this isn't something that happened under the radar. And to that end, let's talk about this. Who starts starving their child when CPS and law enforcement get involved? Who does that? If you were going to starve your child, you would have been starving them way ahead of that, right? You don't start this miraculously horrible behavior, I shouldn't say use the word miraculous, but this heinous behavior that they claim when everyone gets involved. And that's when the precipitous drop happens. So it occurred to me, you know, we have a child who had already been struggling, and Miranda may have been onto something. She was saying, don't give him the bread because then he doesn't eat other stuff and he doesn't have the nutrients. What if the mere fact of this battle of wills over the bread is that now he's really just getting the bread? That's what he's eating. And to the extent that it's harming him in other ways, because they're now under scrutiny and they're just trying to make sure they're doing their best. They're just like, hey, I don't know what to do, just give him food. You know, so it's kind of those, like I said, it's this catch-22. Give it to him, don't give it to him. You're darned if you do, you're darned if you don't. August 13th, Miranda, there is a video that you'll see, and this picture came from that video. And this is the one that the state opened their case with because they think this one line makes their case. It makes for a sensational argument, but it really doesn't make a case. Miranda's saying a whole loaf of bread, and Brandon is saying, he says back, and I'm not gonna lie, it's not the most patient voice. I know that looking back, he's not proud of how he talked in this moment, but out of frustration, Miranda's mad at him because he won't withhold the bread. He says, give him the whole loaf of bread. He eats the whole loaf of bread. And the pattern here is he eats a whole loaf of bread. He still cries for more bread. right? So he's like, see you crying for more bread, bro. Cry for more bread, and I'm going to put your fucking ass in squats. Here's the thing. My husband works in construction field, and he comes home sometimes, and I have to remind him that we're not in the construction world, and we don't use that word as an adverb or adjective, verb, and noun, right? Like they do out there. So we can't take people out of their context. I'm not saying that you may not agree with that word that was used, but in the construction world, it's used and it's not even thought of twice. So again, you cannot be held criminally liable for anything when you use that word. It's not something the state of Texas says, if you say this word to your child, you are a criminal. But I understand the context that it sends. But let's look beyond that. What does he also say? Does he say, I'm going to beat your ass? Does he say, I'm going to do something to you physically? No. He's saying, I'm going to have you do squats. Now, he's a young boy. Dads are trying to raise their sons to be, have muscle. He's thinking that he is doing good while also reprimanding a child. So in putting it in context, you can understand that this is not some father that doesn't want to help his son. It's a father who sees the balance of, look, I'm frustrated with you, but I'm not going to hurt you. I'm going to try to do something that, while it seems like a punishment to you to get you to change your behavior, it's actually going to help you in the long run. Okay. August 14th, the state has shown the photo on the right over and over, but what they don't do is connect the dots for you, because the rest of the photos on that date, he is sitting at the table eating, and you can see that he's drinking 2 bottles of water. I don't know what else happened that day. I don't have a video camera of that. I don't think that anyone at that point thought that this was going to be in a court of law 3 years later. But that is a fuller picture of what was going on August 14th. We talked about the difference, and you can't tell me that this kid, that they have made this this photo seem like it is just the mere image of someone who's going to die or has serious bodily injury because of starvation. We can see, as Dr. Gebhard pointed out, that it is not unusual to be able to see your ribs. And this photo, the angle of it, is going to make your lungs come out further, and it's going to make it more distinct. But you can also see that his belly isn't concaved, even though he's lifting up. August 16th, middle of the night, and again, Brandon's is in blue. Brandon says on the video, why don't you call your mom to come pick you up? And then Miranda says, okay, again, I've messed up the things. Here's what happens. It says, why don't you call your mom to come pick you up? And then Brandon is upset with her because she's screaming at a fucking kid. That's what he tells her. And he says, how come you don't scream at Leo like that? He's calling her out, right? He's calling her out. He's like, wait a minute, I sense that there might be something wrong here because you're picking on Benji. And she says, Leo, I don't cry. Leo doesn't cry every night when people are trying to fucking sleep around here. And he responds, you're the dumbass that likes to stay up and wait and watch when he gets up. And then I don't know how to, he like makes some sound with his mouth, making fun of her in a way. And then she says, now I'm trying to give him a water, and he didn't fucking come. So now he's away, like there's water involved, they're not trying to withhold the water, and Brandon says, okay, then just fucking close the door, come to the fucking room, and close the fucking door, all right, and lay down. I understand you hear the F word a lot in there, but don't lose sight of what the message is. The message is, hey, you're exhausted, you're reeling, you're complicated, you're making this something it shouldn't be. Just lay down and go to sleep. And she says, yeah, well, he's waking up the effing boys. And he responds, so that means for you to scream at him? And then she says, like you don't, he does this every effing night. And then finally he says, yeah, but I'm not screaming at him in the middle of the effing night. So here's what I take from that. When you take out the cuss language, is that he's saying, look, and he doesn't know he's being recorded. This is on Miranda's phone, okay? He's not saying, I know you're beating my kid. He's upset because she just raised her voice at him. So he has no knowledge that Miranda is doing something bad to Benji at this point, and that's important. Miranda's actions, August 17th. Brandon left, and you can see that. Do you remember we have that packet? It's a big packet, Defendant's Exhibit 33. It has the investigative report in there. It has all this information. Brandon left at 6:20 a.m. At 7 a.m., she claims she gets the kids up and takes Brandon to school. Videos of Benji in the car, right? And there's 7 of them. This is weird to me because she's taking videos and then you can see on there that 5 of them go to trash and 2 of them she keeps. She says she was sending it to Brandon, but there's no evidence that Brandon ever got that video. So, but that is the video that I took that picture frame from, where you can see what he looked like on the morning 3 or 4 hours before he passes. She claims she gets tacos, which she does. I mean, you see them on the table. She claims that at 9 a.m. she goes to bed with Benji and the boy's lying next to her, right? Next to her. But the urine on Benji's bed doesn't make sense. And this has been highly suspicious to me because then she claims she wakes up at 10 a.m. Now maybe she's mistaken about what time she wakes up, but she specifically says 10 a.m. that day. And then 911, 911 is not called until an hour later. So I don't know, the state got into some bruising that's on Benji. Never looked into. Just kind of the buck stopped there. When I asked, Dr. Molina, hey, do you know where this is to the medical examiner? He also has swelling on the brain. I don't know if Miranda did something while she was there and then she snapped and it's like, oh my gosh, because there's this, who waits an hour to get help? And also, how unreasonable is it that you have 3 kids in your house, one of them who is either unresponsive or barely breathing and is in need of urgent medical care, and you think it's a great idea to take your time and take 2 kids, 3 kids down to the car and haven't even called 911. That is not reasonable to me. And so, if she did something to Benji during that time period, it is not Brandon's fault. He had no way of knowing. But her failure to get medical care is her own failure. It is not his failure. You heard on there that when he became aware of it, he's like, they asked, did your husband call? We don't have those 911 calls. Otherwise, I would have played it for you. But I played you hers, and hers were highly, highly suspicious. And the lack of urgency, in my opinion, in which she expresses herself. Why not call 911 to the apartment is my big question. What happened at the apartment, we will never know. I asked Detective Sides, well, you knew that the cameras were going off and you knew that they were linked to Blink. Why not contact them? You have subpoena power. Benji and Brandon Sr. and Brandon Jr. both deserved more than that. Because if something happened in that moment, and it's your child, you want to know whether someone did something. But we were so focused on something other than what's really their job and really important that we don't have that evidence. We don't know what Miranda did, but that video would have captured it, and they didn't preserve it. Tacos and drink, the food was available, the locks were unlocked, the bruising on Benji's head, did she cause it? The cerebral edema that we talked about. which Dr. Gephardt said would cause diabetes insipidus and cause that urination to come out as much as it did. Failure to investigate the allegations.
Judge, I'm going to object to this point because this fact's not in evidence.
Suffocation. I'll move along. Suffocation. They could not rule out suffocation. You remember me asking Dr. Molina that, and she just wrote it off. She's like, there's no evidence. There's no evidence because you did not go look. Witness credibility. Julie Center, do I think that she didn't see what she saw? No. I think she absolutely saw what she saw something, but she didn't see it as accurately as she remembers it. But in a traumatic, stressful event, we often misremember. She's saying no stair. I mean, she's saying she's coming down the stairs. There's no stairs there. Does that mean that she wasn't there or didn't see it? No, I'm not saying that. But it also has to be considered that maybe Benji wasn't even breathing. When she says, no, I checked and he was breathing at that time, it's possible that he was already non-responsive. We won't know, but you have to keep that in mind. And given the hour delay, that's what causes me concern. Detective sides, I mean, he questions Miranda and Brandon on the same day within hours of Benji passing for like maybe 30 minutes, an hour, and then never ask them another question again. Is that thorough investigation? He gets information after the autopsy that the bruises, why not call him back in there and go, hey, do you know how this happened? Do you know how that happened? When did he last eat? How much did he have? When did he last drink? These are very, very important questions that inquiring minds want to know. But if you don't know that there is an issue, the parents don't, I mean, at that point, they're under Brandon's distraught, you heard. He was distraught at the hospital. You're asking him about his child like that after his child just passed. He probably wasn't in his right state of mind to even be able to give the details, but nevertheless, you know, the state has all of that evidence. They could have brought that to you. They didn't. The fact that someone can't take or chooses not to take the stand cannot be considered against them, but their statements prior to that to police officers are not prevented from being admitted into evidence. But we can't admit them ourselves because they're considered hearsay when the defense does it, but the state, by law, under the rules of evidence, can get it in. There is no elephant. Remember when we started with this and I said, if you think there's an elephant, you're going to find an elephant? Well, Dr. Molina, you know, Detective Size comes to her and he's clipped out these videos of his timeline and what he thinks happened. And so he gets her off on this track of, oh yeah, it might be starvation. Let's go with that. Because here's the thing. The only thing that we've lost here is 2.2 pounds. And remember when we talked about the other case? That is the only other case in 20 years that had starvation. That child had 7.17 kilograms. The child was alive, it had expired immediately prior to the police involvement. Or after the police involvement. So we know that that child had almost half, was about the same size and stature as Benji and 4 years old, and he had almost half of the weight, 7.17 kilograms. That's huge because when you come back and you look at why she's trying to claim that she knows Benji has starved to death, it doesn't make sense. And when she says that Benji's cachectic, while there are a spectrum of small, little children, there is a very drastic difference, as you heard from Dr. Gephardt, between a small child and a cachectic child. And Benji was not cachectic. No internal photos, so you just have to trust her. On this mesentery that she says is translucent, we were never given internal photos. She didn't take any. And she admitted you can't rule out suffocation, diabetes, arrhythmia through autopsy. Blunt force injuries, she said without adequate explanation. Again, that should have been looked into and asked of Miranda to see what was going on in that house. The labs. I pointed those out to you because she does not take beta hydroxate albuterol, and the other one that are required in order to diagnose diabetes after you pass. And she also, the vitreous glucose levels, as you can see, open up in Defendant's Exhibit 33, open it up. And the lab itself tells you that if you don't preserve it, these labs cannot be relied on, because you have to preserve it frozen, and it's only good up to 30 days, and they don't test it until after October 30th, which is 2.5 months later, and we have no idea if it ever got frozen before it went to the lab, because you're gonna see the FedEx, and it's not indicating anywhere on there that it was frozen when it was shipped, and it was in shipment for 72 hours. So here again, the state has a burden of proof, and they can't rule out diabetes. Now, maybe it wasn't as likely, right? I'll give you that. But the thing is that because we don't have the evidence, we cannot then therefore jump to some type of starvation. Diabetes does result in weight loss very quickly, as you heard, and we'll talk about in a little bit the symptoms that he had. Most likely starvation. In her autopsy report, she doesn't say it's starvation. She says most likely. Well, the standard here is beyond a reasonable doubt. So if you're going to, by her own admission, the state could never even meet its burden, because she can't rule out all these other things.
10 minutes.
Not dehydration. Lucifer, he had his height chart. He said, I only put down the ones I thought would be reliable. Well, interestingly enough, he doesn't put down Dr. Molina's. He instead finds it more reliable to put the one from 97 centimeters on it to make the height chart go up and then down. So I had him do that for you. If you have soda, his dehydration, he speaks out of both sides of his mouth. He says the sodium is 159, so that shows dehydration. But when you look at the urine nitrogen, it's low, and if it's high, it's dehydration, and if it's low, it's protein. So what he's saying is the uronitrogen says it's not dehydration, but he's already told you that there's dehydration. And then he tries to use that same number to claim that it's low protein. It doesn't make any sense, but he does admit that there's no stunning, and that he possibly died from diabetes.
I'm going to object as a mischaracterization of that testimony.
Your Honor, it's quoted.
Ladies and gentlemen, you will remember the evidence is presented to you in court through the testimony of the witnesses. What the attorneys say is not evidence.
We do have some numbers. You can go look at those. The EMS was 300, the ER was 214 for the glucose level. The testimony stated that, at least according to the American Association of Diabetes, 200 is going to qualify you for diabetes. We had excessive thirst, excessive hunger, excessive urination, eating and still losing weight, vomiting, blurry vision. The blurry vision comes in when they're on 7/20/2021. Miranda is telling the officer that, and it doesn't catch most people's attention because nobody would think blurry vision at that stage would be associated with a medical condition. But she's identifying that on 7/20 that he's having a hard time seeing. Okay, causation. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. All right, here's what this really comes down to, is that if Miranda's actions were sufficient in and of themselves to cause the event, then Brandon cannot be held responsible for
Judge,
that.
that is a misstatement of that law. It is a misstatement.
Ladies and gentlemen, the law will be given to you and is given to you in the charge of the court. The statements by the attorneys is not the law of the case unless it is in harmony or agreement with the charge of the court.
I'm going to keep moving, but you get my point, that if Miranda is doing something to Benji in that house, it is not, you cannot use that the morning that he passes, you cannot use that to then say someone else is responsible for an act that she did in that house to Benji that may have resulted in his passing. Mistake of fact. Okay, Here's the thing, if the parents mistakenly rely on the medical professionals after they've told them what their concerns are, and they do everything that they've been told, they're allowed to rely on that mistake of fact, right? Because the medical professionals, they were relying on what the medical professionals told them to do. Also, if he believed, if you find from the evidence that he believed that Miranda was feeding Benji or providing water to Benji while he wasn't in his care, and he was mistaken about that, then that does not go against him, right? Because he did have evidence that the child was being fed and provided water while in Miranda's care. Housekeeping, demonstrative evidence doesn't come in to go back with you. So that January 2019 date is on a demonstrative evidence on that chart. Jury unanimity, each of you has a voice and you have a vote. And the reason we don't have one juror and we have 12 is because it's important that the collective body be able to discuss it, but at the end of the day, you have a right to your own individual vote, and you are asked by law to exercise your vote in line with your conscience and the charge of the court.
5 minutes.
If you're unable to decide, just understand that there's other jurors that would also be hearing, if we're unable to get to a unanimous vote, that while we would rather you have, we need you to vote your vote, but if it comes to that, we will retry the case, but those same the next jurors would have many of the same issues that you already have and are struggling with. So we do ask for you to take the time to really consider all of the issues. Passion, bias, and prejudice. I understand that child abuse cases can evoke a lot of passion and prejudice, but that doesn't mean it happened. That's why you're here to consider everything. And I'm gonna ask you, not just to make the argument for me, because the state's gonna get up and talk, but I'm asking you to make that argument for Benji. Because there's a lot of stuff that didn't get looked at, and that's his dad. And when you go look at that video from July 20th, you can tell that they love each other. This is not the type of situation in which Benji did not adore his dad, and his dad adored him. And I believe that you owe it to Benji to work as hard as you can to make the argument, because that's also someone that he loves. Precedent-setting case. Take your child to multiple doctor visits, child loses 2 pounds, child is having behavioral issues, you tell your child yes or no, and you're sitting here? This seems insane to me. We should all be scared, because if it's not us or someone we know that has a kid that's really skinny. My brother had, both of my nieces are very tiny, but they're not starving, and neither was Benji. Be careful how we judge others, because when we judge others by that standard, we can expect to be judged ourselves. I am not saying that Brandon is a perfect parent, but what I'm saying is that the state has brought you no evidence that he was a cruel parent or that he was a parent that intended in any way to deprive his child of everything he needed. Things do happen. Children do pass unexpectedly. 2 pounds is not something that you are sent to prison over after having already lost your child for something that you cannot explain. At the end of this, I believe that the only right verdict here is not guilty. And I'm asking for you to find Brandon Cervera Sr. not guilty.
Okay. Yes. Okay, we're going to go ahead and take a break. Ladies and gentlemen, you have heard argument. You have heard part of the arguments. You have not heard the full arguments. So please do not begin deliberations or discussions amongst yourselves.
All right, for the jury.
He's not breathing now. So we know at the time that when Benji is taken down, he's still alive, he's still breathing. Also, when we look at Miranda's 911 call, she mentions that other lady who stopped me. We know Julia's there. So, Officer Rosendo Hoyos, call him, he's the reporting officer, he saw Benji at the hospital. What is he telling you? Like everybody who's talked, except for really the defense experts in this case, that he looked very thin. Saw the bruising on his body. Then we brought you to Devin Acosta, who was the CSI in this case. Described the scene for you. Showed you those 5 locks in the kitchen. The locks and the gate in the children's bedroom. Described for you the video cameras in the kids' bedrooms and in the kitchen. And then the locked food, the food that was behind these locks was bountiful and plenty. And you have those photographs and evidence for you. You can see that all of these alleged choking hazards, apparently that these parents are trying to prevent him from getting to. What will you notice about where there are not locks? There's not locks where the knives are kept. Where do we keep chemicals in our house? Underneath the kitchen. Do those have locks on them? No. It's only the food that's locked up in this house. And when you listen to that body-worn camera statement later, you will hear from the defendant's own mouth and Miranda's own mouth, why did we put those locks on? Because he was getting up in the night and eating. Not because we were worried about him choking in the middle of the night. He was getting up in the middle of the night and eating. That's why those locks were put there. So you see this one. This is the first lock that we see in those original surveillance videos back from 6/8 of 21. This was the original lock that was on this pantry. And soon you can see through the videos that apparently these defendants, the defendant figured out he could open this lock. Right? He was able to get in there and get some food. They're not going to have that. What are they going to do at that point? Then they add the exterior lock to this, to the upper cabinet, and to the fridge. I'm sorry, the fridge was already there. They changed the one on the fridge because apparently they knew he could get into the fridge. So that's what we see in this photo as well. We see that these locks on the upper pantry, the lower pantry, more specifically the upper lock, the lower lock. We see also in this one where there's a lock. Where do we not have locks in here? We don't have locks in the bathroom that's in the hallway, the kids' bathroom, where there's medication. They're not worried about that. They're worried about him getting food. So we looked and we saw the cameras. Why would you place a camera in the kitchen? If you're sleeping at night, it's to catch Benji going into the kitchen and getting food. It's a reasonable inference. Then we see the ones in the bedroom. Where is it angled at? It's angled facing the door, right? The door where Benji is getting out on multiple nights in order for him to get some food. Then we saw the 2 locks on these doors, and Mr. D'Amico already mentioned this. You see in one of those videos, the surveillance videos, Benji, he's moving the desk. And he's moving it where? Towards the door, where the gate is, so he can pop over the gate. Well, they weren't going to have that. You have those photos and evidence where that desk is in there. It's locked. Why? To prevent Benji from getting out yet again. This defendant has placed barrier upon barrier upon barrier from Benji getting what is the most essential part of our life, food and water. I mean, just let's think about ourselves when we miss our lunch, how that feeling is. Imagine living in that constant state. That's what Benji's life is like. We see the gate at the door. We see originally that gate wasn't there, but eventually it does. It gets added there, that additional barrier for this 4-year-old, almost 5-year-old, from getting out and getting food. So, brought to you then, Detective Alfred Gonzalez. He's our cell right expert. He authenticated the videos that came from the cell phone, which are state's exhibits number 75, 78, 79, 80B, and 223. You'll have all of those in evidence if you want to look at them. It has the PDF reports with them. You can see when these videos were created. He, again, authenticated the dates that those videos were created. He authenticated the images and the dates that those came from. Those are in state's exhibit number 76. And he authenticated those text messages. Next we have is Officer Oliver Bettis, who he's a reporting officer on July 20th of 2021. We learned why he went out. He goes out there because he gets an anonymous report that somebody is concerned about Benji. Through his investigation and through his testimony, what do we learn? That anonymous caller is the defendant's family member. Somebody who's willing to call police on their own family member because of the concerns that they see on this child. They didn't really talk to Benji and Brandon. You have the body-worn cameras in there. When they talk to Benji on the counter, where's the defendant? He's right around the corner. When they talk to Benji and they take him to the bathroom, you see the video, who's sitting on the bed? Miranda. And when they're talking there, the door's open, and who's right there still? Miranda. They never talk to these kids alone. And Officer Bettis, to his credit, what I can't give him credit for is he fell on the sword. He said, I should have done more. I wish I could have done more. Through Detective Size, you learned about Child Safe. What is the purpose of Child Safe? The setting, you're away from any potential perpetrators. These kids could have been taken to Child Safe, they could have been interviewed, but unfortunately they weren't. So through Officer Bettis, you're able to review the body-worn videos. And you can see Benji asking for food several times. And in that, every single time, not right now, or just moves him away. See, Brandon actually moved the defendant away. Remember when Detective Hale, he puts Benji, gets him, sits him up on the countertop, and the EMS is right here. What does Benji do? First he reaches for that snack, the little kid's treats. He said, oh, not right now, buddy. And then they start asking him questions, again, with the defendant right there. And what does Benji do? He doesn't really respond. He goes back because he's looking for that food, right? Something officers clearly missed. The signs were there. They just didn't pick up, and they should. What do you learn through that? You also learn through that video that the defendant and Miranda say the locks were put in the kitchen because Benji was getting out in the middle of the night and going into the kitchen. This idea that he's choking on something is just ridiculous. He's there, those locks are there to prevent him from getting food. Then we learned about Candace Sanchez, who's the defendant's sister, who called CPS on her own brother because she was concerned for Benji. What do we know from her? That Benji, she used to babysit Benji, and that when Benji was in her care, he ate well. Normal developing kid. Gained weight during that period of time. In fact, she had potty trained Benji during this period of time. That Benji was normally developing during this time that she was babysitting him. And then we also learned that the defendant had told her, oh, he's eating a lot, he's eating a lot. You need to take him to the doctor. You need to take him to the doctor. Doesn't happen really until CPS gets involved. After Candace calls, and that's when you see him taken to the emergency room. Then Amy Floyd. We get a timeline of where Benji was with during periods of time. Benji was with Erica from birth to about January 3rd, 2019. From January 3rd to January 6th, Benji's with Amy. And then Benji moved from her custody to go live with Danny Cervera, the defendant's father. During that period of time, same information that we had from Candace is all consistent. Benji, he had no problems eating. He had no problems gaining weight. Benji was a normal, happy, healthy, developing child. She talks about those milestones that he's reaching. Those milestones that you as parents, you as uncles, aunts, people who have grandchildren, those exciting parts of their life, when they're starting to crawl, when they're starting to walk, when they eat their first solids, all of those things, he's hitting his milestones. And then we showed her a picture because she hadn't seen Benji since he went in. And what'd she say? I know that's him, but I don't recognize him. That's not my Benji. That's not the way he looked. He was plump. He liked it. So Dr. Lucifer is our board certified pediatrician and child abuse pediatrics, former director of the Center for Miracles. He's actually authored a peer-reviewed article about starvation. This is an expert in starvation. What did he tell you? Diabetes didn't kill Benji. We talked about how you die from diabetes. That's ketoacidosis, right? Those signs that Benji died from ketoacidosis. Tells you that Benji died from starvation. And that injury prior to actually succumbing to his death, that injury, the composition of his body, that starvation, up and coming, that was serious bodily injury. So what do we talk about? We talk about the weight trends and the height trends. The weight trends, again, we're not looking at any particular point in time. We're looking at what's the overall trend. He's increasing until really the last 10 months of his life. Again, he was developing normally until his 4th birthday. He talks to you about the lanugo, and you have those photographs in evidence with his back. And that to him, though that hair was consistent with the lanugo is consistent with starvation. Talked about the dehydration that is, again, hand in hand with most of the starvation cases. Talked about the compulsive behavior, and we kind of have to dig through the medical records to look at it. But in it, you can see he's chewing on his fingers, right? That is that compulsive behavior that is consistent with the starvation. You also have photographs and evidence. You have photographs where he has a diaper and then he has what appears to be feces on his hands. It's a reasonable inference that at some point he's potentially eating his own feces. Talked about that lack of body fat on him, the paucity of adipose tissue. Talked about it over and over again. That there's no subcutaneous fat, that mesentery is translucent, it's see-through. And we talked about the importance of the mesentery fat, right? It's there to insulate you. It's there to protect your internal organs. It's the very important fat that you would have. And in this case, it wasn't there. And ultimately, what he tells you, I agree with Dr. Molina. Benji died from starvation. So these are the weight charts that he provided for you, and you have those in evidence, and you can look at them if you desire, and look at what ultimately his testimony is. So then we have Dr. Molina, who is the chief medical examiner of the Bexar County Medical Examiner's Office. Talked to you about Benji's cause of death was starvation. His manner of death is homicide. What is starvation? It's not receiving adequate nutrition. And that starvation is not always the complete removal of food or water. Defense wants to talk about, look, there's photos and videos of him eating. We know he's eating. It's the adequacy, the enough. He's not getting enough to sustain his life. He's not getting enough, what's important in children, to grow. In fact, he's not growing. His body, by weight, is getting smaller and smaller and smaller when it should be getting bigger and bigger and bigger. Tells you that if Benji would have received proper medical care prior to his death, he might not have died. Talk to you about what serious bodily injury is. In this case, it's the death, it can be, but can it also be that weight loss prior to death? That injury, that bodily injury that creates a substantial risk of death, right? So leading up to his death, even that is serious bodily injury. Tells you about what the autopsy process is. It's not just opening it up, looking at his body, externally and internally. It's that death investigation that comes along with it. And what she did, she reviewed all of Benji's medical records, went through, made sure, subpoenaed the health insurance company, make sure we have all of the claims, make sure we can know where he went, where he was doing, what he looked like, what he weighed, because we don't want to leave any stone unturned. We want to make sure we understand what is this kid going through. So, talked about the cause and manner, what supports your evidence. The precipitous weight loss. You can see in State's Exhibit number 111, which is the graph, that last bit of his life, month and a half, that's really quick decline in his weight. Talks about his BMI, which according to the CDC, which again is based on the United States, the population of the United States, talking about his peers here who live here, who have the same, should have the same access to food and nutrition, that it's in less than the first percentile. Talked about that lack of subcutaneous fat, the translucent mesentery, the collapsed small intestines and large intestine. Essentially every expert here says, what does that mean? Well, it means that there wasn't eaten for a period of time. There was no food. Talked about that thymus involution, that at this age she would expect it to see. And what do we know? It wasn't there. It had completely disappeared. And she talked to you about what's the significance of that. It's an extreme stress and situation that you need to be in, the child needs to be in for invalid. What that stress situation be? Clearly starvation that he's been going through for the last 10 months of his life. Talked about the macrocytic anemia. That's not just there on the day of the labs that's run on his death. Those are the labs also prior to that when he goes to CHOSA on 7/21 of 21. That macrocytic anemia is even there. We see those early signs of the vitamin deficiency, which again is consistent with the starvation. Talked about the weight trends during this period of time. Again, tells you it's not an individual point that matters. It's the trends. What are we looking at? We're looking at the overall picture. Talked about the low protein and albumin, what that significance of that is. He's not getting enough protein, and that, again, is consistent with the starvation. Again, no difference in the opinion with Dr. Lucifer. There's the growth chart for you. You can see normal trend even jumps up to close to the 25th percentile. And then that last 10 months of his life, we see beginning a slow decline, but then at the very end, a very quick decline in his weight. So what serious bodily injury includes? Is bodily injury that creates a substantial risk of death, bodily injury that causes death, serious permanent disfigurement, protracted loss or impairment of the function of any bodily member or organ. So in this case, SBI can be the weight loss prior to his death and his death. Doesn't have to be just his death. They want to focus on, well, he didn't die from starvation. Take it out. Take it out. The weight loss itself created a substantial risk of causing death. We have Detective Size, who's a police investigator, who interviewed the defendant, he interviewed witnesses, he had Brandon Jr. complete a forensic interview, and then he got a search of the cell phone, which revealed a lot of information, which is in front of you in this case. So review the cell phone videos and photos, shows Benji wasting away during this period of time. And again, based on the cell phone and who he's with, remember, he is with the defendant from January of 2019 on. When does the starvation start? About 10 months prior. So even before that, when he's gaining weight, we don't have photos of that because we have to get it from the defendant. So with photos we have, he's already in the process of losing weight at the very beginning. That April picture that I've showed you, that is a period of time where he's already losing weight. We get to watch Benji begging for food. And then at the end of it, we get the result of his investigation, which is that the defendant is charged with injury to child causing serious bodily injury. So talk about the surveillance videos for a second. We have one from the kitchen. So what do we see? We see Benji getting out to eat at night. And we see the escalation of barriers to get to the food. We see videos where the gate's not there, and then we see the next one where the gate's there. So we can timestamp essentially when these things are happening. We can see, as far as the bedroom kitchen, we can see the timing of the gate. We can see Benji crying at night for milk and for water. When you look at State's Exhibit number 80B, which the defense already went through you, what is he asking for that night? He was crying for water. The defendant knew he was crying for water. That's what that shows you. It shows you that he knew what was happening with Benji. Because he heard it that night, and it's referenced in their argument the night before Benji dies. Shows in some of these videos that Benji is isolated. Not just in some of the videos is he alone, but look at the conditions in which they live. Leo and Brandon Sr., they have real beds. What does Benji have? He has a dirty mattress on the floor. This kid is treated differently than the other kids. So we see Benji trying to get out for food. He's climbing the fences. He's moving objects to get over. This is a smart kid. He knows what he has to do. He knows that he has to wait until his parents fall asleep at night in order to sneak out and get food that he needs. What do we also see? We see in one of those videos Brandon taking Benji back into the bedroom, probably because he snuck out and he was trying to get some food, puts him in there. What does he say? Shut the fuck up. Why? It's probably because Benji's been crying that night for food and water. But what's his response? Again, like many things we've seen, cry for more bread, bro, and put your fucking ass in squats. Or what? Shut the fuck up. Then we have the phone videos. So we see Benji have consequences for asking for food, and this is 4 days prior to his death. The other video, which is 3 days prior to his death, what do we see? We see Benji shaking, right? Dad, can I have some bread? So if he's having trouble gaining weight, why is the defendant punishing him for asking for food?
Your Honor, objection. That is not evidence anywhere.
Ladies and gentlemen, you will remember the evidence from the testimony of the witnesses as you heard it during the course of the trial. What the attorneys say is not evidence.
So why is the defendant punishing him for asking for food? That's clearly, Benji has consequences. That is the ask for bread again, or put your fucking ass in squats. If they're going to say that, well, he's having trouble gaining weight, why are you putting locks on the kitchen? Why are there punishments for asking for food? It proves that the defendant's knowledge of Benji's condition and the lack of his food and nutrition. We know that the night before his death, Benji was crying and asking for water. And then the night before, the defendant tells Miranda to just put Benji in the room and walk away. So we see these text messages, and they're a little bit hard to read, but you have them in evidence for you. But and defense went through for a little bit. What does he say? Just give him a piece by piece. He don't need to eat dinner. Just give him the bread, and we won't give him anything else. If you're really concerned about him eating bread, and that's all he's eating, and that he might be choking on bread, then why wouldn't you let him have dinner? It makes no sense. He knows what he's doing. He knows the consequences of his actions. So the defense strategy to me, in part, seems like this. It's the Wizard of Oz theory. Don't look at the man behind the curtain. Don't look at what's clear evidence in this case. You got to ignore it. We got to spin it some weird way. We see these two pictures. These are 4 months apart. 4 months apart. And they want to have experts take the stand, and to me, they lose credibility when you can't say this kid looks different, right? There's something wrong with him. Clearly there is something wrong with him. He is losing weight. You can just look at his face, you can look at his legs. It's clear. It doesn't take an expert to tell you that. And we see this video from the night of his death, where he's crying and he's begging. In this video, you have it in evidence.
And objection, Your Honor, the statement of when it was from, it's not the night.
This is from the day that he died, where you see on 8/17/21, where he's asking for bread in the car. And what does she tell you? If he's filming it, just send it to Brandon. We have this video. Remember, he's eating bread, and in this one, what do you hear him say? Cry for more bread, bro, and I'm gonna put your fucking ass in squats. Oh, he's doing that for his own benefit. What benefit? This kid is losing weight. Then we see this one, where Benji's shaking. And I can't imagine what's going on in his head, because the day before, what happens? When he cries for bread, this defendant tells him he's gonna put his ass in fucking squats. So imagine the courage this trial has to have to ask for bread again the next day. So what are the defensive theories? Benji didn't die from starvation. Basically, he's not malnourished enough. He doesn't look skinny enough. Apparently, these experts can look at a kid and tell him that he died from starvation. So they don't even apparently need to even review the medical records. They can just look at a kid. That Benji died from type 1 diabetes. And the defendant took Benji to a doctor, and they didn't say anything about his weight. So I want to talk about these a little bit more, and then the Benji had behavioral issues. So Benji didn't appear starved. What do we know from the evidence in this case? That kids with Benji's same BMI Z-score have starved to death. We know that from Dr. Lucifer, we know that from Dr. Christensen. Dr. Christensen, I'm going to go to him a little bit later, but even in his own evidence, there have been kids with higher BMIs, higher degrees of the criteria of malnourishment, according to the test that he likes to use, that have died from starvation. There's no lethal limit as it relates to starvation. That there's kids with Benji's same or higher Z-scores, BMI, that have died from starvation. And again, why, according to them, apparently you don't need to do an autopsy in order to say the kid is starved to death. You can just look at him. To me, it insults your intelligence as jurors. Your individuals, you can look at photographs and you can see that this kid is wasting away. Again, looking at these photos, it's clear he's wasting away. Type 1 diabetes. Benji did not have type 1 diabetes. Even the defense own expert who told you, Dr. Gebhardt, didn't have type 1 diabetes. We don't see any of the islet dropout in the pancreas that would be associated with type 1 diabetes. No ketoacidosis, there's no acetone in the blood. The symptoms that they want to say are type 1 diabetes, eating, and thirst, guess what they are? They're also symptoms of his starvation. Medical professionals missed the starvation. So, let me pause this one, go back to this. Talk about behavioral issues. And, so what? Kids with behavioral issues, they don't deserve to be starved to death. Depriving them of food and water, it's not appropriate discipline. And depriving them of food and water doesn't solve those behavioral problems. I don't know why it keeps being brought up, the behavioral problems, but it's not relevant in this case. And these are the behavioral problems, I guess, that we're talking about. What do we see? Benji, the good big brother, bringing Leo is something to drink that night. And again, this is a period of time where he's already losing weight. This terrible kid's treating his brother like a brother. So, starvation, signs of starvation. Go through all of these. And what do we have in common? His precipitous weight loss, his BMI, lack of subcutaneous fat, translucent mesentery, all of these things. No defendant's witness can explain why it's not starvation. They just want to say, well, maybe it's something else, right? They just want to put maybe, hopefully you'll latch on to maybe a little bit of doubt. But none of it is consistent with the evidence. So I want to talk about Dr. Christian and his credibility. You got to check, he's got an opinion for you. Charges $600 an hour. My God. At this point, he has billed over $18,000 for his testimony. That was so far. That didn't even include his testimony, his flight here, anything like that. What do we know? While he was an ME, he's double dipping. He's also double dipping while his lab is unaccredited. Because he's doing consultation work on the side. This guy's about the money. The Utah Medical Examiner's lack of accreditation. They lost it in 1995 and they didn't regain it until 2004. It's almost 30 years this ME's office did not have an accreditation. It's 29 years. And during that period of time, it was essentially his whole time that he was chief medical examiner until the very end, that he was running an unaccredited medical examiner's office. And when did he regain it? He regained it when Dr. Molina, the Bexar County chief medical examiner, went to go inspect his lab because they rely on her for accrediting these types of labs. So, lack of credibility. You should show him photos and he wants to, what about the angles? Maybe his mouth is like this. And come on, man. It's an easy softball question for you, but you want to just fight about everything. You're not going to tell me he's losing fat? He looks smaller? He doesn't know the long-term effects of malnutrition. But what was he quick to say? It's not SBI. Okay, what are the long-term effects? I don't know. But you know they're not SBI? They're not serious bodily injury? It's because it fits his narrative. He has to come here. He's testifying for the defense. Well, I have to say it's not serious bodily injury. I don't have no idea what the long-term consequences are. But I can tell you that they're not serious bodily injury. Okay. He also testified to you about what serious bodily injury. He said it's not serious bodily injury, but he didn't even know what serious bodily injury was under Texas law. It's kind of important to know, wouldn't you think? So, he talked a lot about this Medea literature, and he relies on it, by his own admission, to a significant degree in ultimately reaching his opinion. He says that states nearly all cases are severe, but almost 1/4 of the cases he cites were not. It's almost 25% of the cases he said that he cites actually were not what he said. That's like when you ask your kid, they go home, take a test, how'd you do? I got nearly all of them right, and then they got a C. Okay? That does not make sense. One case, and I'm sorry, it's not mild, one case was actually normal in which a person died, a child died from starvation in what the own literature that he's citing. Own literature he's citing saying there's no threshold for lethal starvation. Using this test is just a tool. It helps look at these things. Might give you from perspective, but again, does not provide a lethal threshold for starvation. Long saying, but no simple anthropometric measure provides degree of risk in children. Weight alone is simplest and most reasonable marker. That's what that report said. We talked about it. The weight alone is the simplest and most reasonable marker of whether a child is at risk for starvation. We know Benji's weight. We know his trends of weight. That different criteria, the methods can provide different results. Using one test, he could be mild versus another test, he might be severe. These are all over the place. And that water load tells us that you can die from mild, moderate, and severe malnutrition. You can even die under water load with a normal level of nutrition.
10 minutes.
And that Benji is moderate under Gomez and mild under water load. So, besides some other things for you, but most importantly, that last bullet point is misdiagnosis of abuse and neglect because of carelessness towards children, and records by health and social workers have been reported in the literature. And guess what? It got reported to you in this courtroom for the past 2 weeks. We had carelessness of law enforcement, of CPS, and medical throughout him that failed Benji in his life. So, essentially what he goes through, and he tries to downplay all the positive findings, but then he also doesn't really provide any other reasons why these things might exist. Yes, the lack of the transparent mesentery, that's losing weight. Yes, he did lose weight, but provides no other explanation for you than it just can't be. Just can't be. Wants to talk about suffocation, and there's no evidence to suggest this is a possible cause. Going back to Julia's center and the 911 call, what do we know? He is breathing at the time that they encounter him. From both Miranda, we know that, from Julia. It's not suffocation, ladies and gentlemen. Seizure. No evidence suggests it's a possible cause of death. Again, the literature does not support Dr. Christensen as it relates to your first seizure can be your deadly one, because there's no way to test for it. We know from the 911 call from Miranda that Benji has never had a seizure before. It's not reasonable. The arrhythmias. Again, no evidence to suggest this is a possible cause of death. He did not have an arrhythmia prior to his death. And the genetic testing that they want to allude to, it doesn't show you anything other than he's predisposed. It doesn't show that he had one, that he died from one, he ever suffered from one. Talk about Gephardt just for a second. He's done 0 autopsies, so him and I have done the exact amount of autopsies. Him and every single one of you have completed the exact amount of autopsies. He's had 0 kids in his care that have died from starvation. He has 0 experience in lethal starvation. He's expected to be paid from $7,000 to $8,000 for his testimony here today. He acts like he's wanted doing it out of his goodwill, but there's a check behind it. His theory about weight loss due to dehydration, it's misleading. He doesn't take into account the fact that this child's diaper is soiled already. There's the water weight that he wants to say, oh, well, maybe you got to take the 12.7 and add it back. It's already included in there. He also assumes that Benji was not dehydrated prior to his date of death, and assumes that Benji's weight at those other periods of time, he wasn't dehydrated as well. So, again, he talks about this, he just doesn't look starved enough. The cerebral edema doesn't dispute this as a common finding in autopsy, and I'm not going to go through that whole thing we did this morning, It's like, if Dr. Medina didn't say it would be a problem, but now she said it, it's a problem. It's backwards. Now that Benji did not have type 1 diabetes, he was dehydrated, and what did he tell you? That preventing him from getting there, getting water and food, that would be considered child abuse for him. Talks about what are the long-term effects of moderate to severe malnutrition. Stunting, which can be SBI, heart issues, which can be SBI, liver issues, it can be SBI. These are all consequences, serious bodily injury as it relates to moderate to severe malnutrition. Catherine McKinney, I'm just going to leave it at this. Bless her heart. Okay? She wants to come here and diagnose somebody with type 1 diabetes, but she don't know what labs mean. She doesn't know what anything means. By law, she can't even tell you this kid has type 1 diabetes. I want to talk about charge of the court, concurrent causation. So in order for you to apply that, you have to believe that the defendant not feeding Benji, not giving Benji fluids, and not seeking proper medical care did not cause SBI, and that only Miranda's actions were sufficient to cause SBI to Benji. So you have to show that all of his failing to act, all of it was insufficient to cause his death. All of his acts are why he's here. He is the cause of Benji's death. He is the cause of SBI. Make a mistake of fact. You have to believe the defendant's belief was reasonable. And it has to reasonably that Miranda was giving Benji adequate nutrition and hydration. And it has to negate the elements of the offense. So I want to wrap up is why we are here today. Defense and I can agree on one thing. This case is important for Benji. It's important that we do our job as it relates to Benji. The system, up until his death, it failed Benji. I can't not put it in any other way. A month before his death, this child should not have stayed with this defendant who was starving him. The signs were there. You can see his body on that day. You can see in between his ribs. You can see the signs that this kid is begging for food, and they didn't take him away. The system failed him. But that is why we have our criminal justice system. It is to vindicate his death and hold this person accountable for harming this precious 4-year-old.
5 minutes.
At the end of this case, there is only one true verdict. That verdict is to find the defendant guilty. And that is because what he did, his actions, he is responsible for this child wasting away. He is responsible. He is the parent. He should have protected this child. He should have fed this child. He should have given him what he needed. But what does he do instead? He only has consequences for what Benji needs to survive. At the end of this case, we're going to ask that you find the defendant guilty. It is the only true verdict according to the law and the evidence in this case. Thank you.
Ladies and gentlemen, I'm going to put you in the lead of the deputy. You have the charge of the court with you. You will have it during deliberations. We await your verdict. Thank you very much.
All right, for the jury.
You guys can have a seat. Is everybody here that needs to be here?
From the safety action.
Okay. Okay. We are opening, excuse me, the record on 2022 CR 4915A, State of Texas versus Brandon Cervera. Mr. Cervera is in the courtroom along with his attorneys and attorneys for the state. It is my understanding that this jury has reached a verdict, and we are going to collect that verdict now and bring in the jury. Is there anything that needs to be placed on the record prior to doing that?
Nothing from the state.
Nothing for the defense.
Okay. We are ready, sir.
All right for the jury.
Hope your chair.
You may be seated.
Ladies and gentlemen, it is my understanding that you have reached a verdict, and to the foreperson of the jury, is that verdict unanimous?
Yes, it is.
Will you please hand the verdict form to the deputy? Thank you. I do find that your verdict is in proper form, and I do accept your verdict. Mr. Cervera, if you could please rise. In 2022 CR 4915A, the State of Texas versus Brandon Cervera, verdict form. We, the jury, find the defendant, Brandon Cervera, not guilty of the offense of injury to a child as charged in the indictment, signed by the presiding juror. Mr. Cervera, you may have a seat. Are there any requests from either side?
You just ask for the jury people, Judge.
Okay. Ladies and gentlemen, we are going to go through a process called polling the jury. I am going to assign you a number, starting with the gentleman in the back and moving and ending with the foreperson of the jury. When I get to you and call your number, the question I am going to ask you is this your verdict? Juror number 1, sir, is this your verdict? Juror number 2, ma'am, is this your verdict? Juror number 3, ma'am, is this your verdict? Juror number 4, ma'am, is this your verdict? Juror number 5, sir, is this your verdict?
Yes.
Juror number 6, ma'am, is this your verdict? Juror number 7, ma'am, is this your verdict? Juror number 8, sir, is this your verdict? Juror number 9, ma'am, is this your verdict? Juror number 10, sir, is this your verdict?
Yes, it is.
Juror number 11, sir, is this your verdict?
Yes, it is.
And juror number 12, ma'am, is this your verdict?
Yes.
Thank you very much. Anything further from either side?
Nothing for the state.
Nothing for the defense.
Ladies and gentlemen, I hope that this week and a half has given you some insight on what we do on a daily basis in these courtrooms. These are very important matters that we decide, but they cannot be decided without the help of the community and without your service. On behalf of both parties, I extend my thanks and for your efforts and your energy today and during the course of the week and a half. You are now released from your instructions. You may speak with anyone you wish to about your time and the trial. You do not have to speak to anyone you do not want to. That is completely your decision. But if you wish to speak to anyone about it, you may do so now. I'm going to go ahead and let you go back with the deputy to collect your things. Thank you very much for your time and your service.
All rise for the jury.